Welcome, everyone. Thank you for coming to Capital Clarity today. I'm Sarah Clendenin, the Director of Operations for the Idaho Freedom Foundation. Today, we are continuing our discussion about the child welfare system in our family courts and CPS. Last week, we heard from Diego Rodriguez and watched a segment from the Ryan Matta Never in America film concerning the Baby Cyrus case. Today, we will be hearing from Kristine McCreery, my friend. She is the founder and director of Parents Objective with Essential Rights, also known as POWER. And following Kristine, we will hear from Representative Lucas Cayler from District 11. So thank you for being here.
Well, thank you everybody for being here today. I appreciate it. So I was asked to give a little bit of my story and go into a little bit of detail of our bills, but when Lucas gets here, he will do a much better explanation of the bills and what they're going to be doing. We've been working on them for over a year. So in 2019, I have one child, a son, and in 2019, he became very ill with influenza A. And as a mom or parent would, you take him into the doctors, find out what's going on. So over the course of 3 weeks, I brought him in a total of 6 times. And each time, all they did was treat him with morphine and IV fluids. And he was progressively getting worse and progressively losing more weight. It was so bad that I could not keep Pedialyte down for him. He just would toss it back up again. And so on that 6th time, when we brought him back in, they were going to do the same thing again, just treat him with morphine and IV fluids, send him home. And I said, look, I don't mean to be rude, but there needs to be something else done here for my son. We're just going to be back here in another 6 to 8 hours when that wears off and he's not able to hold down anything. He's losing weight. And we're already a thin family, right? We're not very big. And so it's concerning. And so they ended up admitting him into St. Al's in Boise, and they let me room in with him. At the time, he was 15 years old. And they immediately got a specialist, a GI specialist for him, which I really appreciated. The gastroenterologist doctor, he came in and he said, well, I don't know why they're giving you morphine. Let's get you off of that. Let's get you actual medicine that's going to do you good. And hopefully, by morning, you'll be able to hold down maybe some Jell-O. Well, by that night, around midnight, he was actually able to hold down Jell-O. So bless that doctor. I know he wanted to be here today, but he could not be here. But we actually stayed in that hospital for 7 days. He was not gaining weight. In fact, he was losing weight. And on the 3rd day we were there, we were seen by a master social work at the hospital. And those typically come in when you're there for longer than 3 to 4 days. So on the 3rd day, this woman came in and visited with us separately, and for about 2 hours total. And in the end, she says, well, there's nothing wrong here. In fact, no further social work was warranted in her report. She said, mom's doing everything she's supposed to. He's getting the care he's supposed to. Child is supposed to go home with mom when they release them. The 4th day, we were visited by a psychiatrist who agreed with the master social worker, said, mom's getting the care he needs. He's doing better. His blood labs were coming back normal. He just needed to gain that weight back that he lost. And for some reason, he wasn't. And so at one point when he was taking a nap, I went downstairs to the records department and I got records for him. And I looked at these records and I noticed that the hospital nutritionist had ordered every single day for him to have a protein shake. Had he had those protein shakes, he would have been gaining weight. He did not receive one of them in those 7 days that we were there. And that was why he was not gaining weight. In fact, he lost ounces. So on the 7th day, a new hospitalist doctor came on board. Someone who never saw my son before, we never met, came in and within 20 minutes declared him to the state and said there's no way that this child had lost weight from the flu. Had she had looked back and done an actual record looking at his records and reviewed them, she would have noticed that his weight was a normal weight 1 week prior to contracting the flu that was actually at a wellness checkup from his doctor. At that time, he was 85 pounds, okay? And that was normal for him. And he had gone down to 70 pounds by the time he was in the hospital. That's why it was concerning to me, because I couldn't get him to eat. He couldn't hold things down. Now they're saying, Kristine, I'm sorry, but maybe he had the flu. Maybe, or no, excuse me, it wasn't the flu, that maybe it was COVID, because it was right around that time when COVID was starting to be noticed. So the doctor stated that he needed to have another test, but that test was not available at St. Al's, that it had to be done at St. Luke's. We went and got transferred over to St. Luke's that night, and their admitting doctor said, no, he shouldn't have this test. It was a CF test, so it was a lung test, a disease for it. And he says, this kid, he goes, I looked at his medical records. He goes, he gets sick maybe once a year. That's not a cause to have this test done. And there wasn't another valid reason for the previous doctor at St. Al's to have had that done, except I had learned that was kind of just an excuse to give to me to get my son over to St. Luke's, where they have the CARES department. And the CARES department is a child abuse specialist. And she came in that morning and asked me in front of my son and said, Mom, can you come out in the hallway? We just want to talk to you out here. Looked at my son and told my son that, don't worry, your mom will be right back. I was not right back. In fact, I never saw my son for about 5 more days after that. On the other side of that door were police officers and social workers. We went into a room, they closed the door, they locked it, and they put their phones down to record, and they interrogated me. They called it an interview, but it was not an interview. And she showed me his weight chart from only the 7 days that he was in that hospital. She did not show me what his weight was previous to that. So I asked the detective to please pull that medical record, and you will see what his weight was prior to him getting influenza A, contracting an illness. She said, well, if that's the case, then we don't have an issue here. She didn't do that. And she stepped out in the hallway, came back in a few minutes later, and declared him as imminent harm and danger. And I was not allowed to see my son again until the court said I could. 5 days had passed, and then I saw him again, and his hands were bandaged. And I didn't know why they were bandaged. They went ahead and did that CF test. Well, in that time frame, I had called the lab tech, and I asked the tech what was in this test, because there's some things that he's allergic to. The lab tech said, oh, ma'am, he should not have this test, and I'll let the doctor know why. And there was a drug inside of the test that would have caused him to have anaphylactic shock. So I questioned the doctor who made that CPS call and called me in. And I questioned her, and I said, he really shouldn't have this test. Here's the person I talked to at the lab. And she stood at the end of my son's bed and said that it's okay, we'll revive him if we have to. That's not okay. So she didn't like that about me. She also didn't like that I was questioning why my son wasn't getting his protein shakes. So moving along, because it's a long story and we don't have that long to talk about it. The CPS case took exactly 16 months before I was able to get my son back into my care and control and custody, as they call it. The deputy prosecuting attorney did not like me at all, and she pressed criminal charges against me. It was originally felony injury to child for medical neglect, for not taking my son in to get care. So before you can get a child back into your care in a CPS case, you have to have a criminal case taken care of first. So they came out to my home. They arrested me not once, but twice. And that was halfway through the case. They waited halfway before they even pressed criminal charges. So I had hired, because they start you out with a public defender. And they're state public defenders, and I'm sure there are some good ones, but I was not that lucky to get a good one. And he even told me that he had a hard time talking with that deputy prosecutor. She was tough, I'll give her that. but she was not fair. And she was not looking at what the actual evidence was. She was going off of hearsay because hearsay is allowed here. So I had hired 3 private attorneys, and each one of them had a hard time with that prosecutor. So I hired a 4th attorney who was hoping to be here today. Maybe he'll come here later, Johann Klaus. And he said, and this was halfway through. This would have been in around August, September of 2019. And he said, Kristine, this is going to be a hard ship to turn around. And I appreciate that, because he spoke to me like kind of Navy, right? And we're a Navy family. So my entire family has history of military of some branch or another. So I appreciated his terminology. And he said, this is a big ship. We got to turn around, but we can do it. And he says, and I don't take cases unless I know I can win them. Now, Johann is an ex-JAG attorney, so I had a lot of confidence in him, and I felt like some of that weight I could finally let go of and give solely over to him to take care of. And he did exactly that. We went into the criminal case, and he talked to the deputy prosecuting attorney. He says, you have nothing. There's no evidence here. All you're talking about is a hearsay testimony from a doctor who didn't do the research, didn't find anything, and they're just saying that he lost a lot of weight. Yeah, he did lose a lot of weight, but they also failed him because they didn't provide him the needs that he needed. How many times, and I remember asking the CPS judge, how many times does a parent have to take their child in to get proper care just to have them removed? So I'll shorten it up here a little bit more if I can. In a criminal hearing, in a criminal case, you will have 3 preliminary hearings. So the first one came about, and the other side did not bring their doctor. Second time, they didn't bring their other doctor. Now, on that third time, if they didn't bring anyone, the case was going to be dismissed. So prosecuting side was not able to bring their witnesses, right? So the night before the 3rd preliminary hearing, the deputy prosecutor went and took it before a grand jury, and they indicted me. And that's when I was arrested a second time for the same issue. The second time, now in both instances, when they came out to arrest me, neither of them had any warrants. They were just verbal warrants. They weren't paper. To this day, I don't know what the paper would say because it doesn't exist apparently. The second time though, and both times were with the Canyon County Sheriff. The police were not involved at this time. And they had said, well, you have a no contact order, because in the criminal case, they filed a no contact order. So I couldn't go within a certain amount of feet between me and my son. And so they said, well, he lives at your home. You can't live there. So they actually deemed me homeless. I could not go back to my house. Had they done their research, my son hadn't lived with me for 8 months. He was in foster care about an hour away from me. So when, your attorneys tell you, shush, don't say anything, just do what they say and we'll come and get you out. It'll be okay. I was not quiet. I was respectful. I knew who I was talking to. I was respectful. And one of the deputy sheriffs had brought me into a room, took my handcuffs off and said, ma'am, put his badge down. He says, I just want to talk to you person to person. And he says, first, I hear you. And he goes, and I'm going to release you. He goes, but do you have a proper attorney? Now, at that time, I was on my 3rd attorney. I had yet to have Johann. Had I had Johann, none of this would have happened. I think it would have. I'm so confident about it that I'm fairly certain at adjudicatory hearing, which is your second hearing about 2 months into a CPS case, it would have been dismissed. So attorneys matter. So they put me out with the rest of the people, and I sat in this room, and I kept hearing my name come across their admin desk. People were calling in and saying, why do you have her arrested? Why is she there? She shouldn't be there. And so they let me go. They never fully booked me that second time. I didn't get a phone call. I was just given papers and told to be on my way. And I walked out, and it's pouring rain. New to the area, I'm not from here. So I was trying to figure out, where can I go? And thankfully, a peace officer was outside, and he probably saw I was a little mixed up with where I was supposed to go. And he goes, "What can I help you with?" And I told him, I said, "Just the nearest phone that I could call." And he goes, "There's a Shell gas station a block that way." So I went down there and I called. Soaking wet by the time I got there. They must get this a lot because they're like handing me the phone before I could even ask. And so I called home and my family came and got me. We went back into that criminal case, and it's like an appeal, but it's not called that. It's called something a little bit different. And I'll get to that in a second, but the grand jury report we were able to see, and I went to my attorney's office, and Johan and I reviewed it, and we thought, oh my gosh, there were questions on there that the deputy prosecuting attorney refused to answer and said, those are not questions that we're going to allow. Had that been allowed and answered, it would have exonerated me. And she knew that. And that's why she didn't allow it. So there is no judge during one of those. They're not accounted for. They're just in a room and they talk. So we went back in, and for this was a hard one for me to accept, because the only way that I could get my son back is if I took a plea deal. The deputy prosecuting attorney and my attorney had several meetings, and she had even said, no, we know she didn't do anything wrong, so we'll drop it down to a misdemeanor injury to child. And my attorney said, no, she shouldn't have to be charged with anything. This case just needs to be dismissed. And they went back and forth and back and forth. And she says, no, she loves her son. She'll take the deal and she can have her son back. My attorney, bless his heart, he even said, you know what? She's a quiet, peaceful person. If you want to charge her with something, do it for disturbing the peace, even though I didn't even do that. And she said, no, it's going to be misdemeanor injury to child. And so we went into court that next week, and I took their plea deal. The deputy prosecuting attorney read a letter, because her witnesses never did show up. And she read a letter that was from the CARES doctor, the child abuse specialist, who said that it is in the best interest of the child if Kristine takes the plea deal, she can have her child back. Without ever showing proof. Absolutely nothing. So I sat there, and Johan said, yes, my client accepts the plea deal. I was allowed the Alford plea, which allows you to maintain your innocence. The judge did grant me that. I appreciated that much. And it was a 2-year supervised probation. That was part of the plea deal. And I took the plea deal, and 2 days later, my son was returned to me. Now, in that plea deal, the state, whether it's a social worker, police officer, some kind of official, was supposed to be coming out to my house at least once a month to check my son, to see that he was okay. That entire first year, from January 2020 to December of 2020, not one person came to my house to check on my son. I, of course, did do the follow-ups. I had everything already ready for him. And he was fine. He just needed help getting over the flu, or COVID, if that's what it was. We will never know. The state, so the criminal case was done. We went back to CPS. We got the CPS case dismissed. It was actually, it's interesting that a parent has to carry around their documents, even though this happened years ago, because you're constantly looking over your shoulder. So this is the CPS vacating order that says that they vacated the legal custody and dismissing the child protective case. They never named me as an abuser or neglector in the case. So that was dismissed. That then allowed me to go back to the criminal case with Johan. And like I said, it was kind of an appeal. It wasn't called that. It's called something else, and forgive me, I can't remember what it was called. But you basically go back in, and it acts like an appeal. And I talked to my probation officer, and they have a high turnover there in Canyon County. And I had gone, let's see, I think that was my fourth one. And she was actually a senior probation officer. And she said, you know, I'm not even gonna look at your case yet. I want you to just come to my office like you usually do every month, pay your fee, come back and talk to us. Came back and I talked to her and I brought my binders. And by the time the whole case, all this stuff was done and over with, I had 4-inch binders with everything in it. And not one page of that was ever heard in court to this day. So I talked to the probation officer and she says, this is wrong, what they've done to you. And she opens the file that she was given. And she's looking at what she was given and comparing it to what actual medical records were. And she's like, this doesn't match. Why did you get a charge of medical neglect when clearly you took him to a doctor several times? So she wrote her letter, because they write these letters right when they think that probation should be terminated. And she wrote a letter. The first time the deputy prosecuting attorney said, absolutely not, I'm not going to agree to that. Well, during this, I was already working on a lawsuit. And I was working with a different attorney at that time that could do the lawsuit for me. And we filed that lawsuit in January of 21. Now, remember how I said that nobody came out to my house that entire first year and I had a 2-year probation? Guess who showed up on my door 6 days after I filed that lawsuit? Police officers, wanting to check the weight on my son, wanting to make sure he's okay. And of course he was. However, his doctor stated that no officer, no law enforcement should be coming and disturbing him because of the stress that they put him through and the trauma that they put him through. Now, my son had no medical condition other than having the flu at that time, right? When he was back in his own care of his own doctor, because when a child goes into CPS care, into state care, they typically remove the child from their own doctor and place them with their own doctors because it goes with what they want to have said. So I got my son back in the care of his own doctor again. And he said, you know, unfortunately, it looks like your son has TIA, which is trauma-induced autism. We went back a year later for a well check, and they were able to remove that from his chart because it took a year for that trauma to undo and for him to just become normal again. Now, the state also said that they had a nutritionist of their own that my son was seeing, and it was not a nutritionist, it was a DO, right? Just a doctor, right? Doesn't have specialties in nutrition, but stated that my son had gotten back up to 85 pounds, which was what he was prior to him, right? Getting his illness. And that was all the weight and height that they were going to be able to get out of him. That he's just not going to, that there was too much trauma that the mom caused, but there wasn't. So within 2.5, 3 months back in my care and eating regular foods that he's used to eating, and living a normal life that he used to have, he gained 10 pounds and grew 2 inches. That's not neglect. That's not an abuse. He was able to just be himself. And thankfully, we were able to get that growth still out of him. Let's see. So we went back to the criminal, and when we did that, the deputy prosecuting attorney had to recuse herself because she was named in the lawsuit. So a different deputy prosecutor was then assigned to my criminal case. They had nothing to say in that hearing. Now, typically a judge would take a few days, maybe a couple of weeks to make their decision and come back to you. Well, at that time, COVID was in full swing and they were all virtual hearings, right? So the judge actually made this statement right then and there and decided, no, we are going to dismiss this case. And that is what they did. She dismissed the case, the charge, and terminated the remaining part of my probation. But they also filed my name, the state did, in child registry, the child abuse registry. And they filed it as a level 2, which is 10 years. And I had went ahead and took it before a judge, not once, not twice, but 3 times, because I wanted my name removed. The CPS judge never named me. The criminal case was dismissed. And these are the documents that I got. Just a 1-page, couple of sentences that says the remaining of probation and sentence to be terminated, and the charge in the above enumerated matter is dismissed. That's all. That's all it was. So we go back into the child registry case. We went before a senior district judge, and the senior district judge, bless his heart, took a good look at the case entirely. And he wrote an 11-page decision ordering the state to remove my name and the reasons why. He, in the very first part, says, for reasons stated below in this order, it is to the order that to the director that this matter is reversed. He then states that the misdemeanor criminal charge did not constitute a circumstance of abuse that could be deemed substantiated under any of the elements listed in the IDAPA rules. The IDAPA, for those of you that don't know, are the rules of abuse of which you can be listed under. He just continues to go on. He cites other cases. He explains that the stigma of a child abuser that would be attached to one's name and the reputation by the listing would be recognized as a serious infringement of the constitutional rights of the individual. He states that failure to provide procedural due process to the individuals involved is a substantial failure of rights sufficient to support judicial inquiry. He then explains that the magistrate and the CPS court failed to address an essential element required for finding fault or responsibility, which is fatal to the argument. He continues on, and I won't go over through all of this because it is very long. And I see that Lucas is here with us now. Let's see. It also states here that the CPS magistrate judge did not find or attach a specific fault to a specific person for causing the circumstance in the first place. He goes on to say that the magistrate judge specifically did not find the mother responsible. I mean, you get the gist of it, right? I appreciate this in the end here. He puts that the plea to the misdemeanor does not provide evidence of substantiation under the regulation of either circumstance of abuse as designated in the regulations or of the mother's responsibility for it. The neglect charge was for not taking my son in for that CF test that the hospital themselves could not do until his flu symptoms were better and his labs were normal. That test was negative. So this was filed, and this is just how long it takes for a parent to get their name cleared after something like this happens. This was filed on April 28th, 2021. I finally get the letter on August 31st, 2022, that the means of this incident is now unsubstantiated and your name has been removed from the Child Protection Registry. My son is now 22 and doing very well. He is doing very well. I know a lot of you ask me, and so thank you for that. I appreciate your concern. During this time, when my case was still active, I had even received phone calls from other parents, and some of those parents are with us today. So thank you for showing up here. And I'm not going to call you out if you want to speak after. That's fine too. But this became an issue. It was not just an isolated case, and I was seeing it more and more with other parents, and they were showing me their medical records, and they were showing me their court documents. And I thought, okay, these children did not deserve to be removed from their parents' care. Maybe some needed some resources. Maybe some should not have been touched at all. There was just never an issue. So I formed an organization, and that's where power came into play. That's the Parents Objective with Essential Rights. And what we do is we help parents get through cases like this. And I have had calls that come in where, yeah, there's been abuse and neglect. And I tell them, you know what, you've got to work your case plan. You know, there's something there. But the majority of the calls that we get will be wrongful separated cases. And the majority of those cases are medical issues. So during this time, also, while my cases were still going on, I was learning how to write legislation, learning what can we do about this. This is not just a one-time incident. This is happening too much. It was happening in other states. And so I had drafted a medical kidnap bill because that's what this was. I also came to learn that medical neglect is not defined in the statute for Idaho, where it has many other states have it defined. Last year, end of February, early March, I received a call from Representative Lucas Cayler, and he had said, hey, do you have anybody that's taking your bills yet? And I said, no. And he says, well, I'll take them. He recognized the issue. He saw the concern. And we have met with the department several times. We have met with other parents. We have met with other officials. We have other officials that support these bills. The department, of course, is going to have their say in it. They do recognize that we have an issue. Now, last year we had a different director, right? And so when Lucas and I met with our previous director, he brought up the fact that we don't have medical neglect defined and asked that we bring something forward. And that's exactly what we did. So now we are here today, and we are waiting to have that testimonial hearing on the medical neglect bill. And we hope that we can have that maybe next week, early, maybe. So with that said, I would like to have Lucas come on up and go over our bills that we're having. He can do a much better job at it than I can.
Do a quick microphone swap up here. Okay. Got it down by now? Yes, sir. You gotta see.
While they're doing that, any quick questions?
Does anything ever happen to the people who wrongfully?
Oh, the lawsuit. My apologies. Yeah. So the lawsuit it goes, in chain of command, right? So we went to the district court. District court judge was very much for the state, hated me, and actually stated in a public hearing that if he was the CPS judge presiding over my case, I would be in prison and my son would never see me again. His words. So we appealed it, brought it before the Idaho Supreme Court, thought, okay, this is going to be good, right? The Supreme Court's different. No. Supreme Court had one hearing. They made their opinion, and they said that my lawsuit was frivolous and had no merit, even though we cited 163 violations and 12 counts. The panel of justices then said that my lawsuit does not qualify for the 1983 civil rights case that I brought forward, denied me that right, and fined me a judgment of $100,000 to pay the people who kidnapped my kid. Everybody I listed in that lawsuit. You said it. Yes. Went back to my attorney who handled that lawsuit, and he said, your best option at this point is to file bankruptcy. Get that wiped off if the judge will allow it. Went before a federal judge. Normally these take a couple years to get through. Within 4 months, it was done and over because the federal judge saw it for what it was. And I appreciated his honest truth about it. And he says, ma'am, he goes, I'm sorry this has happened to you. He goes, I'm just charging everything. And that just happened in 2024. So, anything? Yeah. Yeah, thank you.
Lawyers are psychopaths.
I wouldn't necessarily disagree with your assessment, but there are a few good ones out there. And we do have a very good family law attorney in here with us today. And Johan, thank you for coming. So I might have missed the introduction, but for those who came in late, my name is Lucas Cayler. I represent District 11 in Caldwell. And I am going to try to be very mindful of the 23, 24 minutes I got here. So either Sarah or Rachel, give me a, when we hit our closing time here. I do tend to be long-winded when I get started. So I just want to say thank you for everybody coming out today. I also want to acknowledge IFF and thank them for hosting these Capital Clarity events. And so I guess where I start is kind of where Kristine left off. I met her a couple years ago at a campaign fundraiser for somebody completely unrelated to any of this. I just happened to be there to support that person, and I met Kristine and we started talking, comparing notes. And long story short, I found myself in a place where I had more questions than I had answers, and I found myself in a place wanting to get involved and to help because I recognized that there was a fundamental flaw in the system. So everybody remembers Baby Cyrus, right? The big case that blew up here back in 2022, where Baby Cyrus was removed from his parents. There was medical neglect cited. It's a big, long story, and I think everybody probably remembers the highlights on that. Now, at face value, that could seem like maybe a question mark in the system, but then when you hear stories like Kristine's, then it starts to look like and appear that there's an anomaly within the system. And then once I came on board with Kristine and I started hearing these stories that start coming in on a regular basis, sometimes monthly, sometimes weekly, it just occurred to me that there is a fundamental flaw, not only within our judicial system, but within standing law. Okay. Just a tiny bit of background with where this whole thing started. So Title 16 is the section of statute that governs Child Protective Act here in the state of Idaho. Okay, this all got kicked off in 1974 with the Child Abuse Protection and Treatment Act that was brought forward by Minnesota Senator Walter Mondale before our U.S. Senate. And this became law and established a framework at a federal level to provide federal funding to states for the prevention, assessment, identification, investigation, prosecution, and treatment activities related to child abuse and neglect. Okay, since then, all 50 states have enacted and adopted a Child Protection Act bill. That is all found in Idaho under Title 16. There is a massive amount of funding that accompanies these Child Protection Acts. A report from 2022 showed that approximately, so granted we are talking 4 years old now, that across the U.S., there is approximately $34.3 billion of funding that goes to the states that have these Child Protection Act laws. And most of it is a mix of Title E and, Title 4E and Title 4B. Title 4E funds foster care and permanency assistance, and Title 4B funds child and family services. Okay, and just to give a little context here, what does that look like at the state level? Well, between two appropriations passed last year, session 2025, Senate Bill 1108 and 1208, we have a total of $130 million that is appropriated between state and federal funds that fund youth safety and permanency, formerly known as child welfare, and also foster care in this state. Now, if you were to take and break those numbers down, and I'm going to take the funding for the foster care program, which is $74.6 million. If you were to break that down by the current number of kids, rough number of kids that are in foster care right now, this data is a couple of months old. We had not quite 1,200 kids in foster care as of November 2025. And if you break that $74.6 million down by 1,200 children, what that comes out to is approximately $62,400 being spent per child per year. Now, I need to clarify that I do not believe that the entirety of that $62,400 goes to a child. I've heard some other numbers, obviously a lot lower, but it does show that there is a overwhelming amount of money that is available to fund foster care and child protective services. Right, so there is an appetite on both the state level and the federal level to fund these child care program, or not child care, I'm sorry, to fund youth safety and permanency and child foster care programs. And those numbers only grow bigger and bigger every year, right? So I think that I think what we can deduce from that is that to make the substantiation and the claim from the agency to the state as well as to the federal government to keep those numbers that they're being funded by year upon year is we need to make sure that there is a program in place and the children to fill that program. Now, I know that sounds kind of bad, but just to give a little context here, when we're talking about numbers, I'm a big numbers guy, right? In 2024, we had over 24,000 cases within the state of Idaho that were referred to Child Protective Services. Okay, that represents approximately 5% of all of the under 18 or minors that live and reside within the state of Idaho. That is a huge number. Distill down a little more. Approximately 15,000 of those cases were actually investigated. Once again, we're distilling down even more. The majority of those cases were they were investigated and they determined that there's no needed follow-up. But we get down to a number of about 1,700, 1,800 children. And 990 of those that were taken into foster care were eventually reunified with their parents, meaning that we had about 660 that were left in the system. So we've distilled down to yet a very small number, but I'm sorry, 660 is not a small number, especially when we're talking about children. Which leaves a lot of question marks. Now, I've also pulled data from the Department of Health and Welfare because I've been very curious, as has Kristine, about the number of cases, the number of children in foster care, how they break down by county. And of course, the larger counties with the largest populations like Canyon and Ada are going to have proportionally the largest numbers of children, right? And then we also get statistical data and hard numbers on what those cases were, what they were initiated over. Medical neglect, according to the numbers that Health and Welfare has provided, accounts for 0.8%. If I remember correctly off the top of my head, about 20% of those numbers were neglect. And I asked about crossover, and they said, well, there's possibility that there's crossover. But even at 0.8%, that were actually cases of medical neglect, is there the potential that some of these could be diagnosed incorrectly? Could they have been reported incorrectly? Well, right off the top of my head, I can point to 2 cases, or 3 or 4, of ones that Kristine's agency is, her organization that she's working through, that they're trying to work on reunification with the family right now. But I've been told in talks with the agency, with Health and Welfare, that what I'm trying to do, what Kristine and I are trying to do, is legislate a one-off case. And I fundamentally disagree with that notion. when it comes to the separation of a child from the parents, there can be no disagreement that this is a very grave matter that is going to, one, forever alter the course of that child's life, and number two, it needs to be made with the absolute highest standard of evidence that can possibly be found. We have sought to correct some of these legislative deficiencies in our law by bringing a total of 5 bills. A couple of them are under some rework right now, but one of those is medical kidnap, that defines the wrongful removal of a child from its parents based upon the premise of medical neglect. Needless to say, the Department of Health and Welfare has come out swinging hard against this bill. They don't like it. Well, in fact, they absolutely hate it. The chairman of Health and Welfare Committee refuses to hear the bill because he thinks there's problems with it, because the department thinks that there's problems with it. And Kristine and I, and even Mr. Klaus, our attorney here, we have sat through hours and hours of deliberation in a good faith effort, mind you, with the department to try to discuss the nuances of the bill, to find their objection, to go line by line through the bill and find out really like what part of this legislation are they in disagreement with. And they maintain that their hands will be absolutely tied if we enact this law. Not just them, the agency, but also law enforcement, as well as anybody in the medical industry or profession who gets involved in one of these medical neglect cases. And what we have done is we have put a cause of action into the legislation and have enacted some very stiff penalties for people that are charged with medical kidnapping. Okay? And I think that's important, because if there is no redress for wrongs done against the people by the government, then what keeps the government in check? Unfortunately, since the medical kidnapping bill is kind of sidelined at the moment, not forgotten, because there is work being done, and we are going to be hopefully reintroducing it here, if not this session, hopefully next. The medical neglect bill that we're bringing also had a cause of action written into it, and that's the one thing that killed this bill on its introductory hearing 2 weeks ago. So in a good faith attempt to try to work with the members of the Committee on Health and Welfare, and with Kristine's permission, we struck out the cause of action, which unfortunately puts the law in a position of not really being able to be legally enforced. There's no penalty involved. And I would just like to remind people that the legal remedy, when there is a legal right, and having a cause of action, the ability for a private citizen to sue the government or a government entity or somebody that's wronged them, this is not new. This is nothing that we just invented yesterday. In one of the most famous cases where it actually discusses the rights require remedies concept, Marbury versus Madison from 1803. And in this decision, Chief Justice John Marshall wrote, "The very essence of civil liberty certainly consists in the right of every individual to claim the protection of the laws whenever he receives an injury." He also stated the famous principle, where there is a legal right, there is also a legal remedy. And with one of the other bills, a bill that establishes greater requirements of training and imposes limitations and duties upon social workers, also known as our Social Worker Reform Bill, that I did try to introduce into the Health and Welfare Committee yesterday. and it got voted down. So we're also taking that one back. We're going to try to make some changes. I proposed this idea to the body with the understanding that, once again, like I've just laid out to you all here, and I think that the vast majority of you would be in agreement, when we're talking about the separation of a child from its parents, we need to do so with clear heads, with clearly defined law, with clearly defined limitations of every agency and every entity that's involved. And the frustrating part about all of this is because so many people in today's society believe in the institution of government, the institution of academia, the institution of higher education. Well, I guess that's academia. Sorry, I repeat myself. The institution of the science, the institution that the doctors know best. And when I say doctors, I'm referring to those in allopathic healthcare specifically. And we, the citizens, are not allowed to challenge. And if we do challenge the thoughts, the narratives, or the authority, we're often labeled as right-wing extremists. We're often scrutinized through the lens of being domestic terrorists in many cases. It's a very difficult thing that we have gone up against. And the only way that we reclaim the rights that we have is to exercise those rights, but there also has to be provisions put into law to do that. Our laws, our statutes, our state codes have been crafted over many decades to lean very much in favor of the institution of the state government. And I would like everybody to know that we do have 4 branches of government, not 3. You all thought that we had 3. No, the bureaucracies are the 4th. And the bureaucracies, I hate to say this, are the number one entity that influences the legislation that comes and goes through this Capitol. It's not we the people. It's not the legislators. It's the agency. I know I need to wrap up here real quick. I guess the thing that I would like to leave everyone here with is these situations where medical neglect is happening, where parents are being wrongfully accused of medical neglect. Those two things have to be separated. There has to be proper definition and statute that is made to protect the rights of parents. And ultimately, that's what this comes down to, is protecting the right of the parent. The parent should have the ultimate say and the decision-making capability of determining their child's health care, of determining where their child goes to school, and everything downstream from that. The government needs to be in a place where they understand that law, and they are made to respect that. And that's what we're attempting to do through this legislation. So finally, and I'll close, we are working to create a new system going forward. Is it going to happen today? Likely not. Next year, let's hope. We can only pray. That's where the citizen activism part comes in. This is where calling and emailing your legislator when big bills like this come through, being on the newsletters of people like myself, being connected through social media to see what we're working on, because we do publish updates. And when we put out calls to action where you can call and email your legislator and say, I demand a yes vote on Bill XXX, or demand a no vote on Bill XYZ. I thank everybody for coming today, and I turn it over to you, Sarah.
Thank you so much for being here today. We are pretty much out of time. We have a hard stop in this room at 1 o'clock. So if you do have additional questions, Kristine, would you like to come up really quick and give us the contact information for Power, please?
Sure. At the back counter down there, there is green and blue colored brochures. They look like this, and it has our contact information on it. feel free to contact us or contact Lucas. We are both happy to answer any questions, concerns, or issues you might be having. Just real quick, during this time that we've been up here, I've got another call that we need to talk about a case that just came in. So, of course, we'll vet it and make sure there isn't anything else there that we don't know of. One quick thing on closing, and I know we've got about 2 minutes here left. Another reason why I formed this organization and am working with Lucas on legislative bills is because not only just other parents that have come to me, but the social worker that I had halfway through my case, after, when you go to a CPS office and you have a meeting with your son, I'll call it a meeting because it's really not a visit. It doesn't feel like it. You're watched and you're recorded, right? So when that was over, the social worker talked to me in this recorded room and said, I know that there's no abuse and no neglect. I said, great, let's go tell the judge that so I can get my kid back. She says, no, it's not my job. She then proceeded to tell me that whatever she says in front of the judge will do. And that's very true. This is what got me. She then stated one final fact. She said that if she had the time to reverse over half her caseload, she would, because they don't belong in foster care. Now, if that was true of one social worker in the Caldwell office, can you imagine if it was true of the other social workers in that office, if it was true of Idaho, of the US? And let me tell you, it is. There are tons of other cases that are happening, not just here, not just in the US, they're in Canada, they're in Australia, they're all over in Europe, they're everywhere. And I've talked to those people. I know they exist. But thank you for coming today. We greatly appreciate it. Thank you.